All right. Hello and welcome to Navigating Utah's River Access, a three-part webinar focused on stream access in Utah. Today is our second webinar in this series, and it is titled Utah Stream Access Rights, Responsibilities, and Enforcement. I am Chase Lamborn, the Assistant Director of the Institute of Outdoor Recreation and Tourism, and I will be facilitating today's webinar. Just to provide some background on the Institute, we are formally recognized by the Utah State Legislature and provide research and technical support to help communities, governmental, and non-governmental agencies plan and manage outdoor recreation and tourism in Utah and beyond. We are very excited to be hosting this webinar series, and we hope the information and perspectives shared will be valuable in helping people understand the rights, responsibilities that we all have regarding water access in Utah. So before we get started today, I just want to thank the Office of Property Rights Ombudsman and the Land Use and Eminent Domain Advisory Board for funding this webinar, along with the educational videos and a workbook that we will be releasing in June. And another thing that I would like to do is just provide a brief disclaimer that the purpose of this webinar is to provide practical and educational information about stream access in Utah for both private landowners and the recreating public. Efforts have been made to ensure this information is consistent with Utah's current stream access framework. However, it is not legal advice. Please consult applicable laws, agencies, landowners, or legal counsel when specific questions or disputes arise. So, as I just mentioned, this webinar consists of three parts. The first webinar was last week, which was titled The Past, Present, and Future of Stream Access in Utah. And there we discussed the history of stream access law, the current law governing stream access, and how things may change in the future. That webinar is currently posted on our YouTube channel, which Liz may be able to put a link to that in the chat if you are interested in following up on that and seeing what we had presented there. And today is our second webinar, which is titled Utah Stream Access, Rights, Responsibility, and Enforcement. And the goal of today's webinar is to provide practical information for landowners and the recreating public. And we've also invited law enforcement to describe the common conflicts they see and respond to, along with tips that everyone can use to help reduce these types of incidents. And then our third and final webinar, which is next week, will be held on June 2nd at 11 a.m., is titled Working Solutions in the Current Framework. And the goal of this webinar is to showcase ways private landowners and the public are working together in the current framework to develop opportunities that are mutually beneficial for both parties. So today we are joined by three very special guests who have extensive experience with Utah Stream Access. Our first presenter is Mr. Michael Begley, who is an Assistant Attorney General in the Utah Attorney General's Office in the Natural Resources Division. Mr. Ryan Williams is the Associate General Counsel in the Office of Legislative Research and General Counsel for the Utah Legislature and staffs the Legislature's Natural Resources, Agriculture, and Environmental Interim Committee and Legislative Water Development Commission. And last but not least, Major Chad Bedridge is a 25-year veteran of law enforcement within Utah's natural resources. Most of his career was spent in Utah County as an officer and sergeant before transferring to headquarters in Salt Lake City, where he currently oversees all the conservation officers. So the outline today, I also wanted to share this. So I've already discussed this with our presenters, and I mentioned it during the last webinar as well. But I just want to let everyone here know that the purpose of this webinar series is not to openly debate what should or should not be regarding Utah stream access. The primary purpose of this series is to share and discuss the current legal framework. So what is? With that, we'll first hear from Mike Begley, who will be defining what public and private is in Utah, and then he will be outlining recreationist rights and responsibilities as defined in the Public Waters Access Act. Then Mr. Ryan Williams will be outlining landowners' rights and responsibilities, also as defined in the Public Waters Access Act. And then finally, Major Chad Betridge will share the common conflicts law enforcement encounter regarding stream access and with tips to help reduce these conflicts. So after these presentations, there will be a short question and answer session. So if you have any questions, please put them in the chat and we will get to them at the end. So now, without further ado, I will turn the time over to Mike Begley. Mike, the time is yours.
Morning, everybody. Can you hear me? And do I have my screen up?
Yep, you can just put it in presenter mode and you should be good to go.
Having an issue here.
That should make it. I got it. There you go. Looks great now. All right, time is yours, Michael.
Thank you very much, Chase. Good morning, everybody. It's a little unusual presenting at a webinar where I can't see everybody, so bear with me. This is my first opportunity. I usually like to see everybody, but please bear with me on a Tuesday after Memorial Day, and I have a lot to cover. I will try to do my level best. I've been warned to be brief as possible, so here we go. Those that don't know me, thank you for the introduction, Chase. But I am Mike Begley. I'm originally from Wyoming. I come from a ranching background, but I've also really enjoyed fishing and skiing my entire life. And so most of my career has been in Montana, where I went to University of Montana School of Law. I practiced law in private practice before my small family, wife and son, moved to Utah based on my wife getting a really good job here. So the last 7 years, I've had the privilege and honor of being able to represent various agencies within DNR, and but focusing primarily with my client agency, Forestry, Fire, and State Lands. I don't know why there's a scribble on my screen, but I guess we're going to have to deal with it. Um, just a slight disclaimer too, based on some, just to be very careful moving forward, and didn't want to misinform anybody. Just to add to Chase's thoughtful disclaimer, I also want to share that I am doing this on the behest of Chase, and there's not an attorney-client relationship, so this is not legal advice or a legal opinion. And none of the statements that I'm going to make here today should be imputed to my client agency or any agency within DNR. Okay, what are the goals of today's presentation that Chase wanted me to try to articulate? Principally, the best way to make sure that we're lawfully recreating Utah waters is to make sure what waters we're dealing with. And in so doing, I'm going to walk through all the different kind of categories of public and private waters in Utah. That will be a large portion of my presentation, and that will be the first portion of my presentation. After that, I will try to delineate the best of my abilities, not only the recreationist rights and responsibilities under the Public Water Access Act, but some other anecdotal kind of hints based on the fact I am an avid fly fisherman and recreationist myself, and I fly fish all across the West. And there's a couple of, at least some nuances and some granular things I just offer for advice, just to make sure everyone's legally responsible, and also utilizing these waters as safely as possible. Okay, starting with the categories of ownership. This is really important to kind of as a general foundational understanding of what's accessible to the general public and what is not. And so there's five main categories that I've listed for your consideration and orientation. Water on public lands, if it's located exclusively on public lands, that's the easiest category to understand. Uh, the second category is also somewhat a little bit more tricky. It's a little bit more legally nuanced, but and if you are to determine where you want to recreate is sovereign lands, then I think there's just a couple of fundamental ideas you just have to keep in mind when recreating on sovereign or water over sovereign lands. And the third is whether or not you are able to recreate on waters that are accessible under the Public Waters Access Act. There's a carve out from the legislature that affords public access in certain circumstances, and it's wise to understand what the definitions and what those uses are under the Public Waters Access Act. But if you do so, you can access legally waters. And then you have to get into the category of the ownership with respect to what's private lands. Now, private lands doesn't necessarily mean that you cannot access. What the Division of Water or Wildlife Resources has a wonderful program called in the Walk-in Access Program, and I'll go into that. But in essence, certain landowners enter into contractual arrangements with landowners so that you can access their property for whatever it is that is allowable under that lease agreement or whatever contractual arrangement they have. And then finally, we want to be respectful of private property interests and adjacent private lands, and especially when there are non-navigable streams or private ponds that you will need to have express permission from private landowners to access that. Other that, if you do not, you will be unfortunately in trespass, and no one wants that. Okay, just going a little bit more granular, just to make sure we're all understanding kind of the categories. The easiest one is, if there's water that's exclusively located in a federal or state park, those are usually and typically free to recreate on, hike through, or float upon. However, there's a couple caveats. You want to make sure that what you check with whatever the ranger is on those parks and ensure that you're following whatever specific regulations that might be applicable at that time, making sure you have permits if those are what's required to access. But otherwise, public lands and water on public lands are generally free for you to access. Just make sure that you check in with whatever the local ranger or whoever else is that can give you good, solid advice and recommendations and make sure that you're compliant with whatever the regulations are for those parks. Second large category is those waters that are above sovereign lands. This is again, like I said, sovereign lands, it's state sovereign lands. And I'm going to generally guide you through what that means in terms of a legal framework so that people have a general understanding of why those are public lands so that you can recreate over on the water. Generally, those lands are based on an equal footing doctrine principles. Those are, in essence, the equal footing doctrine is where, all the subsequent states in the Union are afforded the same rights and sovereign interests that were originally granted to 13 colonies. So our Constitution and the U.S. Constitution affords equal footing of all of those. And what that means is that if there is a stream or a lake that was navigable at statehood, the state should be the owner of the beds and banks of that navigable water body. And that navigability for title also is inclusive. It really is geared towards the beds and banks, but it needs to be formally adjudicated in a court of law. And evidence of navigability of statehood is really important, and it's very fact specific. And a couple of, if anybody's interested in this, certainly there's two U.S. Supreme Court cases that Utah sued the United States and prevailed on with respect to owning the beds and banks of not only Utah Lake, but the Great Salt Lake. And those cases, I think the Great Salt Lake is 1971, and I believe the Utah Lake is somewhere in 1984, I believe. If navigability has been adjudicated, then it would fall within, and this is my client agency's code, 65A. Title 65 is forestry, fire, and state lands. And so what that basically, the definition of navigable for title sovereign lands means that you can access those beds and banks up until, and this is the important part of the sovereign land definition, up until the ordinary high water mark. So there's a longitudinal kind of demarcation line that the public really needs to be aware of. And that the ordinary high water mark is a little bit tricky, but it usually is a vegetation line. But what we want to be careful of is that we protect and preserve the adjacent riparian or whoever's the landowners that are adjacent to those properties, so that you have to stay within the ordinary high water mark, and if you go above it, you will be in trespass. if people are curious, there's a really well-established test to whether or not a state owns the bed and banks of any navigable waters. Basically a commerce-based test. It's under the Daniel Ball. It's a United States Supreme Court decision, 1870, and it's generally applicable, sometimes in varying forms, depending on the state. But this is kind of the impetus, the catalyst of what we now know of how you determine sovereign lands. More specifically and more practically, if anybody wants to know, Forestry, Fire, and State Lands website, which I've included here, has the categories of the state sovereign lands that have been adjudicated. And generally those are, and you'll find them in this website, is the Great Salt Lake, Bear Lake, Utah Lake, segments of the Colorado, segments of the Green, and the Jordan River. So if anyone wants to check and see what the sovereign lands there are available for public recreation in the state of Utah, you can access this site. I put this little image just as a little bit of a caveat and kind of a warning is I think everybody knows that web-based or even functions like Onyx do not establish property rights. And so I just caution the public and just to make sure that you check in with Forestry, Fire, and State Lands or the applicable agency before accessing, because sometimes the maps are not showing exactly what would be sovereign lands. Okay, moving on to the next category, the Public Waters Access Act. This is a statutory mechanism and it's really devoted towards recreational access. And it kind of follows the principles of sovereignty, but it's really a little bit more looser, in my opinion. But it's really pretty straightforward in terms of what would be a recreational activity. Under the first statutory section I have here, you can recreate the public water if it's navigable and it's on public property. And importantly, the recreational activity is not otherwise prohibited. And you'll also see in the definition, navigable water is a little bit different than the extensive Daniel Ball, but it's pretty close. I think the test has generally been adjudicated fairly similar, but nonetheless, it's basically, is this river or a body of water that would be accessible by a general commerce or trade? Okay, so what is the recreational access is allowed? It's pretty narrow, and the code does a nice job of saying here's what's allowed and here's what's not. So, recreational access includes floating, fishing, and specifically waterfowl hunting. Now, importantly, with respect to this slide, please consult the actual statute because the waterfowl hunting, you'll see the ellipsis has a couple other caveats. They're kind of public safety related. Specifically, for example, you can't duck hunt for within 600 feet within a house, something like that. But it's always wise to look at the entirety of the code. What also is not allowed is specifically provided, and it does not include any other hunting except for waterfowl hunting and wading without engaging in fishing. And apart from those, the Recreational or the Public Waters Access Act allows specifically for floating, fishing, waterfowl hunting. Okay, the private land, again, going back to the walk-in access, that's afforded under Utah Division of Wildlife Resources. More to that in the next slide. I think I mentioned already, if you happen to not want to bother somebody, but get landowner permission, that's always the polite and legal thing to do. You're otherwise going to be in trespass. You need to be an invitee pursuant to landowner's permission. And obviously, all the state agencies and everyone, we again need to respect private property rights on all public waters. And if there's ever any doubt, please check in with your local agency or law enforcement. Okay, so what is the walk-in access program? This is a neat program, and there's a lot of acres and river miles and ponds that are afforded walk-in access based on this program from the Wildlife Division of Wildlife. And what it basically is in a nutshell is an agreement between the division and a private landowner. They enter into lease agreement The lease agreement allows for whatever it might be with respect to the access afforded, and it's important to know exactly what that agreement allows and doesn't allow. And then, absent what's allowed, the landowner retains all other, sticks or property interests that they would have, so long as whatever's been granted isn't impeded by the landowner. Okay. I know this is a kind of a whirlwind, but I want to make sure that I give and I'm sensitive to the other presenters' time. So the second component that Chase wanted me really to focus in on is what is legally required so that you know you're using Utah waters responsibly. It's super important, and obviously everybody wants to be good stewards of these natural resources. So I'll briefly discuss those next. If, in fact, the Utah waters that you want to recreate on are sovereign lands, as mentioned, the state owns the bed and banks. So you still need to consult whether or not the state and federal regulations allow for activities. But for example, there might be sandbars that are located within those sovereign lands that you can freely access and play around on without violating anything. And obviously, sometimes you also can anchor with respect to if you're on a segment of river that's been designated sovereign lands. Again, with the caveat just to make sure that you're following whatever the appropriate regulations are for that stretch of river you're on. If you're under the Public Waters Access Act, the important thing you have to remember, and this is the responsibility of every person that wants to access these waters, is just to make sure in the first instance that there's sufficient flow that would allow kind of safe travel down without, ruining whatever the watercraft you'll be using, but more importantly, making sure that you're not just traipsing down the river without floating on it, because that's no fun with anybody. And if in fact you do are elect and you're responsible to go down the river when there is sufficient water flows, then you are allowed to incidentally touch in case you run into a shallow patch, and then you can keep moving. You can also portage across dangerous areas. So, for example, there's a fallen log, or if there's a head gate or some sort of dam structure that might be in the way of a river, for example, you can portage that, but it needs to be in the most direct, least invasive, and closest to the water. So we just need to be mindful and that we don't want to traipse around other people's property, and you just want to make sure that you're in and out of the water as quickly and easily as you possibly can. The last thing you can do, which is different, I don't know if anybody's ever floated the Deschutes in Oregon, but you cannot in Oregon fish while you're floating. It's an odd kind of regulation on those waters in Oregon, but here the legislature has crafted a specific provision which allows people in Utah to fish while they're floating down public waters in the state of Utah. The important thing to remember with respect to walk-in access to use this responsibly and legally compliant is that you have to go in and make sure you get the annual walk-in access authorization number. And it's good to do that while you have good cell service. Sometimes I have in the past been out and I'm trying to do a walk-in access. It's usually not in relation to fishing, but say pheasant hunting or something like that. And I don't have good cell service. And I didn't get the walk-in authorization number, and I just have to turn back or go somewhere I can get cell service. So it's just important to plan ahead on that. And then it's also recommended also to talk to the Division of Wildlife and make sure you get a brochure or you talk to someone there so that you can understand completely what's allowed and how you can access that walk-in appropriately and prudently. Entering and exiting Utah waters is you know, there's a lot of unknowns about this particular area of the law. When I was in Montana, this has been litigated somewhat significantly, whether or not someone can access from a bridge to a navigable water, or, in Montana, there's a little bit more public access afforded to rivers and streams. So the best thing to do here is just to make sure that the gold standard is to usually just try to access from, you know, points that are established through walk-in access points and or state or federally maintained and recognized boat ramps if you're on a river or a lake. But again, with everything on this presentation, please consult public and private resources just to make sure and do your due diligence, just so you know where and when the extent of your float's going to be. If it's, you're going to be pushing it, you don't want to get later on in the day or night and you're going to have to, trespass across someone else's property just because you didn't plan ahead appropriately and didn't understand how long the float was going to take. So again, just a little bit of prudence and due diligence, I think, will make sure everybody's using these natural resources appropriately and legally. Again, this mantra is consult and confer with appropriate agencies at all times. And please also, I know that there's a lot of legalese in this presentation, but there are certain regulations, state and federal, on certain water bodies. For example, the Green River, you have to make sure that you haul out all of your waste. And so those are just another layer just to make sure that you're using all of these natural resources appropriately. And most importantly, after you got all this done, please have fun. And if you're fishing, catch fish. And Chase, that's the conclusion of my presentation.
Hey, thank you so much, Michael. Next, we will be hearing from Mr. Ryan Williams. So if you want to pull your slides up, Ryan. And he, like, as I mentioned earlier, he will be providing an overview of landowner rights and responsibilities as outlined in the Public Waters Access Act. So Ryan, the time is yours.
Excellent. Thanks, Chase. Can I just get a confirmation that you can see my slides? Are those working?
Yeah, just pop it into presentation mode and you'll be good. Yep, that's it.
Awesome. Okay. It's always a tough act to follow Mike. I get to see him in action, working with the legislature, working with his natural resource agencies. And it's always a pleasure to watch him do his thing. He's very good at it. So as Chase mentioned, I'll be reviewing some of the landowners' rights and obligations under the Public Waters Access Act. I am an Associate General Counsel for the Office of Legislative Research and General Counsel for the Utah Legislature. So it's always fun to kind of review where the statutory language came from. I wasn't around in 2010 when HB 141 was passed, but Representative McKiff and Senator Stowell passed HB 141 back then to kind of establish the act, and it's been tinkered with a little bit over time, but it's largely remained intact, kind of preserving and defining the requirements for what recreators need to do on public streams and what private landowners can do to protect their property interests as recreationists kind of use these waters. So kind of as a roadmap, I'll run through what the legislature in 2010 was thinking when it instituted the Public Waters Access Act, just briefly to kind of give a sense of what the legislators what the legislature's intention was, and then some useful terms which Mike has covered a little bit, and then get into some of the landowners' rights. It wouldn't be an attorney's presentation without a legal disclaimer. This is the third one you've heard already this morning, so apologies. But I just wanted to note that as staff for the Office of Legislative Research and General Counsel, we are a nonpartisan office, so we don't advocate for any pending or past legislation. We assist legislators in drafting their policies and developing their policies, but we don't take positions on any of that legislation. And I'll be presenting a primer essentially on landowner rights and obligations under the PWAA. But I would encourage any private landowners who think they may want to exercise a right under the Public Waters Access Act to engage legal counsel if you want to rely on some of these rights, because they are very fact intensive, as Mike mentioned. So policy declarations in 2010, the act. I don't think it's controversial to say that the act was in response to the Conitzer decision. which determined that floating over public waters was allowed, and that standing on the banks of over public waters on private banks was allowed for an indefinite period of time. The legislature was concerned that the Conitzer decision conflicted with the private property rights expressed in Article 1, Section 1 of the Utah Constitution. Specifically, allowing persons of the state to possess and defend their private property. The legislature again and again in declarations, which the legislature often declares, its intention in passing black letter law that controls, and just to kind of give the sense of, to give the public some context into why the legislature is passing certain laws. So you can see under Title 73, Chapter 29, Section 103, this is where the legislature expresses its declarations of policy. The intention to restore private property and recreationist rights that existed prior to the Conitzer decision, and to kind of reaffirm the floating right recognized in JJNP, which I think was what a 1982 decision from the Utah Supreme Court. So getting into some PWAA terms, Mike mentioned navigable waters. I'll kind of mention what public waters mean under the Act, and how the Act defines public recreational access kind of as a lead into landowner rights. So Utah law defines navigable waters. Essentially, could commerce be conducted over the water? Has it been conducted at the time of statehood? Mike did mention a prior Utah Supreme Court decision. I think it was Utah Stream Access Coalition versus Orange State, where the Utah Supreme Court actually did state that the test for navigable waters is the same as the federal test. So was the water commercially viable at statehood, essentially? These are the types of waters that are subject to the Public Waters Access Act. And there are some litigated examples in Utah of stretches of public waters, navigable waters that have been deemed navigable. The Green River is one, Colorado, stretches of the Colorado, stretches of the Weber, and then Mike mentioned Utah Lake and Great Salt Lake in 1984 and 1971, respectively. Another term that's defined is public water, and that's any water that's regulated by the state. So these kind of are two overlapping bubbles of the waters that qualify under the PWAA must be navigable and must be public. Kind of that Venn diagram, and that's any waters that are regulated by the state, which I think is a more inclusive term than the navigable term. It doesn't include impounded waters, right? Waters that have been stored, waters in migratory bird refuges or areas, reservoirs or ponds exclusively on private property that aren't long-term channels or rechanneled natural streams or rivers, and then jurisdictional wetlands, controlled by the Army Corps of Engineers. And then public recreational access is also defined under Section 102, subsection 7, which essentially just means a public recreational area is the area where the public can incidentally touch or float over to engage in recreational activities. The Public Waters Access Act kind of restores how these areas are established over time, and it takes it back to 1982 after the JJNP decision, where if an area had been used for 10 consecutive years in a manner that was not permissive by the landowner, that was open and adverse, and again, the landowner was aware, but the public was still using it anyway. That is how the public has established a right to access those areas, and those are areas that private landowners can't close off to the public, essentially. So, those terms. Let's get into landowner rights. Landowners may restrict public recreational access. They also may protect themselves against the establishment of public recreational access. And then there are some tools to kind of enforce how a landowner goes about that. So first, under the Act, a private landowner may restrict access if the land meets certain qualifications. So if the land is cultivated land, if it's agricultural land, or if the landowner has properly posted the land or fenced the land. So then that needs to be signage that is conspicuous, that prohibits public entry, that reasonably restricts how the public can access that land. And then fencing similarly, has to convey that it's prohibited entry to the property. A landowner may also direct an unwelcomed person on the waters to leave. And enforcing that is a matter of, trespassing the person from the land, or, if it's a repeated problem, the Act does allow for the landowner to seek an injunction against persons that are recreating against the landowner's permission. So here, some examples: the Victory Ranch up on Provo River, signage that's been posted out that's supposed to convey to users of the river that it's private property, not open for public access. Similarly, I think this is on the Weber River, private landowners, trying to establish that this area of the river is not for public recreational access. So similarly, but slightly more thinking, long term, landowners may want to prevent an area from becoming a public recreational access area where, if it meets the terms of it's been used for 10 years or longer, it's been open and notorious use, it's been against the landowner's permission, then that land is then deemed, a public recreational access area. So one way that landowners can prevent the establishment of these areas is by giving permission to those using on the river. Then it's no longer, open and adverse. And recreation users can use the area without the area becoming, a long-term public recreational access, that the landowner can then, revoke permission once granted, and then, close down that stretch. So again, a landowner can prevent the establishment via signage, via fencing, via directing individuals to not use the river. And then some enforcement tools, obviously, as I mentioned, trespass, standard on private property. You engage local law enforcement to have that done. If the problem's persistent, the Act also provides that landowners may seek injunctive relief, and if recreational users can continue using the land, the courts will determine the remedy there for the landowner. The Act also provides for quiet title actions for recreational users, or for state agencies for that matter, that if a state agency or a recreational user wants to determine whether a stretch of a river is open for public recreational access, they may bring a quiet title action in a Utah court. Now, a little bit of protection there for landowners is if the action is brought without a reasonable basis in law, then a landowner, or I guess would mostly be the landowner in this case, can petition the court for attorney fees if the court determines that the quiet title action is kind of unreasonable. Landowners are also required, if they do fence their stretches of the river, which a landowner can do for agricultural purposes, that the fencing does not pose an unreasonably dangerous condition. So if that's an obligation that's on the landowner. The landowner must also, if it's a public access area and there is fencing, the landowner must provide gates or ladders or other facilities for portage around that fencing. I've tried to be quick. I've tried to be brief. I think we're open for questions afterwards, but I will provide my contact information and pass it on to Major Bettridge for the next segment, I think.
Thank you so much, Ryan. Yeah, so just as Ryan said, we'll pass it over to Major Chad Bedridge, who will be providing an overview of law enforcement perspectives on stream access conflict. So, Major Bedridge, the time is yours.
Thank you. Appreciate it. Appreciate the information that was given from our other panelists. It's really great information, and I think what we've learned from this is it's just not a simple, can I go to the river? Can I not go to the river? There's some complications to this. And the complications usually come on the result of those complications is usually where the law enforcement steps in. And what I would like to maybe encourage the public to understand is it's on you to understand this. It's on you to know these rules, where they apply, where they don't apply. We can share as much information as there is. It's on the internet, it's everywhere, it's all out over there, but it is your responsibility to understand these rules and how they apply. What I wanted to, maybe a couple of slides. I don't have a whole lot of slides. I just wanted to talk a little bit about some of the things that we run into in DNR law enforcement. This first slide is of the Provo River. It's a beautiful day, and it looks like a great place to go hang out, which everybody wants to. And then of course that leads to this, which this is a photo that was taken on the Weber, and what I want to say is law enforcement doesn't have a problem with this. We actually want people to go out and enjoy the resources that we have. We just want them to do it safely and correctly. This seems a little chaotic, but there's absolutely no problem here as long as everybody's enjoying the recreation safely and properly. Some of the things that people need to pay attention to that's already been brought up is respecting the private property. And if there's signs that are up, follow those signs and do not take those signs down. And ensure that what you are doing is on the up and up. And as I kind of talked about, make sure that you have information going into it. And just because something was posted on Instagram or Facebook or whatever doesn't necessarily mean that it's accurate. You need to do a little bit more on your own part to collect some information. Signs, they're everywhere. This is up Provo Canyon. I happened to go up and take some photos of some different places. There's lots of information on these signs of what you can and can't do along these places. Sometimes there's signs that maybe are extending it a little bit too far. Their purview goes a little bit too far from what the intent of the sign was, and that's where some information, collecting information on your part will come. I will guarantee you that the landowners are going to have information of what they can and can't do. The public needs to have that same information, and then that will reduce conflicts between the two groups. Life jackets is a must, right? You got to be safe, and honestly, our officers in DNR spend a lot of time writing tickets for people who don't follow this rule. We have accidents every weekend. I was just looking through our information from this last Memorial Day weekend, and it was just every day there were multiple accidents on OHV, on the water, and it's just we can't stop all accidents, but if you have a life jacket, you're gonna be in a lot better shape. This photo next to the life jacket photo is an access point up on the Provo. This is where, it's designated for you all to use, right? To enter the river at this spot. And as was mentioned previously, don't access the spots that aren't open for access, meaning use the spots that have already been predetermined that you can get into the water and float it. Private property is a huge thing, right? There's going to be signs, there's going to be all sorts of different circumstances that you're going to be able to be notified of what of what is where you can and cannot go. Please, 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 I can't stress this more, but follow these signs and and do your best to be a good recreator, a good citizen. Um, as was mentioned previously, we have a lot of walk-in access locations around the state that DWR has set up. I wanted to reiterate that not all of these locations are set up the exact same. Some are for fishing, some are for hunting, some are for both, but you need to have that information prior to going onto those locations. Another thing that I kind of wanted to reiterate on the sovereign land access, specifically on, the Great Salt Lake, Utah Lake, things like that. There's no vehicles allowed to be down there on those once you get it down below that high water mark. You can access it on foot and stuff like that, or take it or on a boat, but you can't drive your car down on it, or four-wheelers or different things like that. There's still certain limitations of what can and cannot be done on these public lands. So again, it's on the public to understand what those rules are. I ask a law enforcement officer; they're more than happy to talk to you about it. But as was mentioned previously, I'm definitely not a lawyer, so it's important that you get good information and then follow that information. And honestly, I think that's all of my slides. So if we wanted to, if there are questions we can open up that maybe the public would like to talk about, Chase, then maybe we can lead into that, or I can talk some more. I just didn't want to, I just wanted to have some information, a little bit of time for the public to ask questions.
Yeah, I think that's great. We have had some questions come in. So
Let me stop sharing. Hang on.
Okay. I will open it up to the questions. And so to kind of follow up on something you had just mentioned, Chad, can a landowner detain somebody who is or they believe to be trespassing on their land?
I would highly encourage that not to happen. If I'm the landowner, you don't want to put yourself in a bad way regardless if there's misunderstandings or anything like that. But photographs, license plates, things like that, to where the law enforcement can do follow-up if they're not able to get there immediately, that's the best route to go. I can't think of a really good outcome of somebody saying, from the old Barney Fife, citizen arrest, I'm keeping you here. That does not feel like a really good outcome comes from that. But again, photographs of the individual, what they're doing, and license plates, things like that, that is the best route to go.
So keep the situation calm, document as much as you can, call law enforcement, and try to take care of it.
Absolutely. And may I say, there is no group of people more passionate about Utah and their resources than those who use it and those who own it. And there's passions on both sides. So this is an incredibly passionate group, and those passions can butt heads and cause problems.
Understandably, for sure. So another question is, what, in your experience and within your law enforcement officers, if there's a conflict over determining whether something was incidental contact or not on a piece of private property, how do your officers approach that? And what guidance can you help give landowners and voters to help kind of better understand that process or the situation involved?
Interestingly enough, about a lot of these things is if the law enforcement officer isn't there on scene and witnesses it, they can't take action unless somebody else says, I saw this and I will testify to this in court. So an officer comes up and throughout almost all of DNR investigations, they will collect as much information as possible, interview witnesses, take photographs, and it's an investigation. It specifically on the incident that you're talking about, it's not going to be an immediate thing that happens unless there's overwhelming evidence that this did happen and we can making an action off of the evidence that exists there. But normally, our officers are going to collect information, interview people, compile information, and go and talk to an attorney about it, the prosecuting attorney. Officers don't prosecute. Officers take information, give it to the attorneys, and the attorneys decide that there's enough information here to file information on a crime. So that's really what the officers are going to do. 97% of the time when they're not there to witness an actual violation.
Okay, thank you. And then this one is, I'm going to open this up to everybody, all of our panelists, and I don't want to get too in the weeds on this one, but maybe just outlining kind of the general process of how this may take place. So the question is that, so evidence was provided to the state, historical evidence documenting pre-statehood commercial use on Utah's major waterways. And so there's, with that evidence, whatever that may be, will the state take that evidence and evaluate whether there's navigability or not, or do each of these sections have to be litigated individually to determine their navigability?
I guess I can step into that one a little bit, just based on kind of authority here. And one of the guiding cases, if this member of the public would like to take a look at it, is a decision out of, again, Montana. It's PPL Montana, which requires a segment by segment analysis of navigability. So there is, to answer the latter part of your question, or the public's question, Chase, is that it is a segment by segment analysis. And the best way to describe it is that in Montana, there's a segment of the Missouri River that has the Great Falls, which is really not passable. But Montana, when it went up to the Supreme Court, said, well, if we do one segment, we can claim the sovereign title to the entirety of the river. And the United States Supreme Court said, no, you have to do it by segment by segment. The first part of that question is a little bit more challenging. I think that ultimately there's resources at stake and there's decisions that need to be made. And I think ultimately what my client agency tries to do is, you know, make sure that they're responsive, but also making sure that they're not going to be litigating something when they don't have the resources to do so. So if there's a quiet title action forced by a landowner and we believe it's sovereign, then we'll probably enter into that action in that time.
Okay. Does anyone else want to follow up on that in any other perspectives?
I mean, I would just second what Mike said, that these are fact-intensive processes that require, these are hammered out in the courts between, opposing parties. And then they're determined on a, like Mike said, a segment by segment basis. I mean, the legislature could weigh in on this. It would require there to be enough support in the body, and it would require probably public petitioning their legislators to weigh in on, expanding what public access means under the PWAA. But that's a matter of, the public engaging their legislators on that question.
Okay. Here is another question. So, as recreational pressure continues to increase statewide, and the demand for these water resources also continues to increase greatly, what are the best practices? And some of you have already mentioned these in your presentation, so maybe you just want to reiterate these points. But what are the best practices for landowners, local government, enforcement agencies, and people out on the landscape recreating to reduce conflict, improve consistency of adherence and implementation of the PWAA?
And maybe if I could talk to that a little bit, specifically on the recreator side, it's unfortunately it's kind of a joke in law enforcement that when people go to the mountains, they sometimes don't bring their common sense with them, and I don't want to be flippant or anything like that. I mean, I really want people to understand that DNR law enforcement wants them to go and enjoy the resources that we have. But as I said, we want you to do it with common sense and an attitude that this is a great benefit to your life that we have this resource, and it needs to be shared by everyone. And the more that we have that attitude towards it, the better, the less conflicts there will be. I have no doubt that photo that I showed of all those people, if any one of us owned that land and all 200 people showed up on that might aggravate us, right? We're outnumbered. And I think that the recreators can reduce conflict greatly just by having a good positive attitude and a I will work with you type attitude, regardless of the circumstance they come upon.
Okay, so I would just add on to that. I think that what's I think not fully understood by everybody, but the DNR building, even though it's not in the best location in the planet, it has some of the most knowledgeable, passionate people that want to help. That if anybody that's in the recreating public, if you just walk right in the building, there's Wildlife Resources has some wonderful people that are just there to answer any questions. And I don't think that service is taken, up enough. And so I think just again, just people doing due diligence. And Ryan, I don't know if you had any other further comments on the landowner perspective.
Well, I would just say, there's a principle, a legal principle, a tragedy of the commons, where if there's a large enough shared space, sometimes it can go into disrepair because there's not one person looking after it. And I think just the principle of look after the space you're in. Landowners, I think, are, almost in every case, reasonable people who, if there's no kind of disrepair or misuse of the land, can be reasoned with, and will our understanding. So I think just being courteous of property that's private and public, it goes a long way, as the major was saying, to resolve conflicts before they even become conflicts.
Mm-hmm.
And if you screw up, own it. It'll be okay, right? So.
So I guess to follow up on that point, another question that we had is, what are some great resources for both landowners and the public to try to understand the access point landscape around them? Where can they enter? Where can they exit? Where are people going to be coming from? Where are they going to be getting out? Just, is there one single resource or multiple resources patched together? Do you have any recommendations there?
I'm not aware of a single resource. I mean, I know that Utah Lake has a GIS map for all of its public access points. I would assume that there's a resource similar, or maybe developed on a patchwork basis. I don't know. Do either of you know?
I've seen a really great map on the Forestry, Fire, and State Land website regarding roads and different type of roads, but I haven't specifically looked on to the rivers and the access of waterways. So I'm not 100% sure on that.
Okay,
I mean,
so I would like to just add that again, just put a plug in for my client agency. That if you go into the Forestry, Fire, and State Lands website, and I'm just going to give maybe a shout out just for as an example. We have a sovereign lands manager in the Green and Colorado area down in Moab, Tony Mancuso, and he's extremely knowledgeable and he knows all of the legal access points, and he would be a great resource for someone that wants to recreate, for example, down in that very well used area. And so the folks that work at FFSL, they want to help the public and they're very knowledgeable. So I would really encourage people to reach out to any of those sovereign lands type folks.
And along that same line, really quick, there's 5 different regions for DWR. Each has a regional building that can get you in contact with an officer to ask these questions.
And to add onto that, online resources are great, but there is no substitute for the people that run our agencies in the state, and getting familiar with your state agencies and their regional offices and being able to call the people that staff those offices is pretty priceless. They're there. I think the public should use them.
So from what I'm hearing is there are a lot of people out there who are very passionate and want to provide this information. If you just reach out to them, you'll get what you're looking for. Okay, well, with that, we're at the top of the hour right now. So first off, I just want to thank all three of you and everyone attending this webinar. I really, really appreciate it. So we'll conclude the second webinar. If you have any additional questions, please email them to Liz, and Liz will send those questions on to our panelists and see if we can get you the answers that you're seeking. And so again, yeah, thank you for attending. Our second webinar will be next week on June 2nd, also at 11 a.m. For more details, you can see our website where you can register for that and get a link just as you did for this one. And yeah, again, thank you for attending, and we hope to see you at the next one. Bye-bye.